And would you mind sharing that again one more time, please?
That I'd rather get an estate plan than a will. Yeah.
Better, it may be better to get a trust or an estate plan
Yes.
versus a will. Okay, that's one thing. So trust versus will. That's one thing we're gonna put on the list of things to talk about. What are some other things maybe we wanna add to that list of talking points?
With
Taxes.
oh,
Yeah, brother.
this is Sharice. I was gonna say with a trust, you
Oh,
don't
sis-
have to play probate.
Okay,
Interesting.
so avoiding probate, yes.
Funding account.
Funding the account, and you also mentioned taxes.
Yes.
Okay. What else do we got, guys and gals? What else do we got? Or what are some other things that maybe you guys may want to know or feel you should know when it comes to estate planning? You're creating a trust.
Is it complex? Is it
Is it
complicated?
complex? Is it complicated? This is a great question because oftentimes people, and I think maybe like if unless there are no other questions, I think we've got a couple of good talking points to move forward on our conversation, right? Um, I think really this is probably the best place to start is with the complexity of a trust, right? Now, um, by show of emoji or by show of hands, you know, how complex is a will? Is it really raise your hand if it's very difficult or complicated? Not seeing any hands, no emojis, nothing in the chat. Okay. So
Maybe as complex as you want it to be.
a will could be as complex as you want it to be. All right, that's a good statement. And it can be. But I'll tell you where a will gets very complicated is when there was no will that was in place and someone has kicked the bucket and now a family has to go to a court of law in order to get the letters of administration, which is what it's called, right? That's that whole process. You're going to the court to apply for letters of administration to issue or access counts of the deceased, right? So if you don't do the planning ahead of time, is it complicated? Simple answer is maybe not for you, but for the people that you're leaving behind, it is. Because now they've got to go through the whole navigating of the court system to make sure that they, cross all the I's and dot all the T's and not miss anything, right? Or just to get there ahead of anyone that maybe you don't want having access to your stuff. So in not creating an issue of battling out in court, right? So this is kind of a good place to really start. And good sir, did that kind of help to maybe answer the question of complexity when it comes to trust? Thank you very much.
Yeah. Well, yeah. Basically. So basically, well, no, because I've seen some of the questions in the trust.
Yeah, you remember some of those questions in the interview that we
Yes.
did for you.
And then I have a review on it, and I have another portion of it, so I know it can be just like a will, but even more intense.
Right. And so like let's kind of address why we may want it to be a little bit more complex and not overly simplified is because remember that we're doing planning for when we're not here anymore, right? Like when or if something happens to us or if we need someone else to act on our behalf because we're incapacitated, right? So, does it help to create complexity within your trust? The simple answer to that question is it really just depends on what kind of assets you have, right? What you want to put into your trust and how you want your trust to operate. Okay. So now bear in mind that when you create a trust, you know, a trust to answer what the other question, I'm gonna just move this question around and just like kind of put it in order of what I'm gonna say precedence. All right, so I'm gonna put this complicated question up top. We're gonna talk about this question, this part of the conversation next. Avoiding probate. Now, a trust, when we create it, avoids probate. How does it do that? Well, it's already notarized, right? And it's already been witnessed, and it already details how the assets within a person's estate should be distributed to the beneficiaries. So because it's already been put in place, and for those that are thinking, well, I know there are a couple of different flavors of trust. The irrevocable flavor, which is the one that you can't change. Once you create it, you set it, you forget it. And that may benefit someone who's got a lot of income, but for someone who's still building their wealth, someone who's still building that income, that high earning potential, a living revocable trust may be the kind of flavor for them, right? But in either case, both will avoid probate, right? Because again, it's your rules, it's what you said you want to happen, and because it avoids probate, there's no public record of your estate being inherited by anyone to the public. So the beneficiary's information remains private and confidently held in trust. And we can talk about some other things when it comes to that as well, right? So I think we've already answered the question of a trust versus a will, but I'll just touch on that very quickly, right? Which one is better? Well, how many people would like for their last will and testament to ever be challenged by somebody else? How many of us actually want our last will and testament challenged? Anybody? Anybody? Okay. So now if we don't want the last will and testament to be challenged, then a will is certainly not the option that we want to take advantage of. And here's why. Is anyone familiar with the Aretha Franklin case? She recently passed a couple of years ago.
No.
Okay. Would anybody like to share what they know about the Aretha Franklin case?
It's almost similar to Prince. Isn't similar to Prince that they died without a will and they went to court, start fighting, and assets went to whoever stepped up and asked about it. I'm not familiar with Aretha Franklin myself, but I know that it can cause a lot of hectic.
So almost a little bit of the opposite. Prince actually had his will, and he had some good estate planning in place, but there were some things he didn't exactly plan for, and so those things still got challenged in a court of law. Aretha Franklin, for those that are not familiar with her case, she had a couple of different wills. One of those wills was written down on a napkin, and one of her family members brought that piece of paper into a court of law and challenged another will that was in power or in effect, right? Which created an estate battle that, quite frankly, is still being resolved to this day, right? Does anybody want that kind of a result? Family members bickering and fighting over your assets, your estate. I see the brothers nodding no or shaking his head no. Absolutely, I don't want anybody having to go through that. This, and out of curiosity, I have my own reasons for not wanting my family to have to go through that. But would you share with me some of you guys's thoughts or reasons as to not want your family to have to go through that?
For me, it's my mother helped with a lot of people's estates. Um, being that she was a hairdresser, but jack of all trades. So um, she would help people estates because you'd have family coming trying to take what was rightfully the person's or the family members. Like let's just keep it a buck, like a family member's estate trying to get certain assets or claim the whole property that the person is even living in while they're not fully incapacitated, but like they're just in a vulnerable state. And luckily she was able to get to it before it was had gotten that far. And just seeing how other family members come in when the money's about to be available, and you never see these people ever. Like you've been around this person and you don't ever see them until it's like, oh, it's a money grab,
Right.
you know. And I've seen it 2 or 3 times, so I can understand the importance, being that I've had to help these people uh, sell different things in the house to
Right.
put up money for the estate or pay things that need to be paid off before they can finish things and bury people.
Yeah, and you bring up a really good point in that statement with people having to sell assets that were of that person's estate, an estate being the entirety of what a person owns, right? And people, when they don't do the right kind of planning, or they're maybe not speaking with someone who has their best interest at heart, they're just looking to just take advantage of a transaction instead of establishing a relationship that's going to last longer than the transaction. Um, you know, a lot of gaps, get created as a result of that. So, we want to avoid that for our family members. And I kind of agree with some of what you mentioned. Um, did anybody else want to share like maybe some of their reasons as to why they don't want their family to have to go to court and battle it out and all that sort of? I saw the madam unmuted herself earlier. Did you want to add something, or I'm sorry, you're muted. I can't hear you.
I know you were referring to me.
Yes, yes.
Oh, well, I just wanted to like, I want to know more about a trust, but basically, I'm trying to help my parents who are already they're 72 years old and they're ready to, draw a will or a trust. Like they don't know which direction to go. And since I'm the oldest, it always falls on me to try to guide them in the best way to go. And I have two younger sisters, they're twins, and it's like they are always want to like they're so impatient with everything in life. So it's like my parents, they in their minds, they wanted to leave a legacy, like generational wealth, you know. But my sisters, they just want to like just get the money and run. Like I don't know how to, because my parents have a brownstone in Brooklyn. And it's like they are thinking like, what am I going to do? It's time for them to set a plan. They feel like it's time now. But it's like, I don't know. I don't want to direct them the wrong way. So I'm trying to like read books or, even listening to you to try to get some ideas. And, before I go into the law side of things, like talking to a lawyer, because I mean, I had one lady that I found in the newspaper. You know how like when you leave in a supermarket and they have like the
Right.
neighborhood papers and stuff. And there was this lady and she only did wills. And I was about to like go along with it, with her and everything, because I talked to her during the pandemic. I was able to vet a couple of people, but I'm thinking that she was saying the right thing. And then one of my friends was like, why are you going to direct your parents to a will? And that's when they told me about probate. So I'm like, okay. So then I asked her about it, and I was talking to her the whole 2 years of the pandemic. As soon as I said, well, what about a living revocable trust or something like that? This lady got an attitude with me, like she's ready to cut me off. And I'm like, what? Wait, what happened?
Not to interrupt you, but can I ask you if you understand as to why he may have gotten upset? Because like I mentioned on one of my stories, I was going to tell people why it is that certain people don't want you to know this information. But can you take a guess as to why it is he doesn't want to talk about trust or a living revocable trust in that case?
Well, I was under the impression that it would be less money for her in the long run, some kind of way. Because if I'm asking you, if I'm asking for your advice, like you're supposed to be, the professional in this, you're supposed to guide me the best way. And it was
Right.
a fellow African American female. So I wanted to go to her before I go to, you know, the other people, the other races, and I'm thinking that she would be looking out for me and my family. But as soon as I mentioned that, like she now she don't want to talk to me. She only want to talk to my parents and all this. Like it just went to the left very fast. And so I knew right then I must have been on to something. What my friend had guided me, with that knowledge was great, so that's why I'm here, because I just want to know like how to lead my parents, because they've been thinking about it since the pandemic, which made them start thinking about things, and they started getting their assets and properties and stuff together. But now it's like, okay, now they're 72 and they're like, okay, we gotta move on this now. So I'm just trying to get as much information as I can to try to, you know, help
So
out in every way I can. And then while I'm doing this process, I'll know what I need to do
okay, so
for myself and my family.
let's kind of dive in a little bit more to you've expressed, because for those of you who are not familiar with the probate process, I took an opportunity to just jot down these things. So if you, just in case, if you're on a mobile device, turn your phones sideways and let your screen's orientation change, that we can see more of what's in front of you. But in the probate court, you have some participants, right? Number one, we know that when we go to the state court, for the state in which a person may have died in, we have to ask the state court to get involved and act as a mediator, a neutral third party who's going to basically act like King Solomon to divide a baby. All right, like that's one of the best analogies. I don't know if anyone else is like familiar with the whole King Solomon analogy. Couple goes to King Solomon. They say, we have this baby. We're the parents. Another couple shows up. Hey, that's our baby. King Solomon says, let's cut the baby in half, give an equal portion to both parents. One parent says, whoa, 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 whoa. Let the other family have the baby. We don't want the child to be hurt. What does the state do in that instance? What did King Solomon do? He said, you know what? You're gonna get the baby because you actually cared the most about the baby, right? So like in similar fashion, King Solomon is the state or the court, right? And then you have the party seeking administration of the estate, the baby, right? Which would be parent couple A and couple B. And then you have witnesses that may appear or may have been present for the creation of an estate, like a person who prepares a will, right? Like an attorney, okay? Like an estate planner, like a financial planner. So because fitness category can be so big, when those people show up, it's actually an inconvenience to their schedule. And so the state tries to compensate them sometimes if they're asked to, balance the books, like for taking the time to make a special appearance for the estate court, right? So now let's look at how many hands are out asking for money to help prove that there's an estate. The state, number one, has got I said the brother is laughing right now. Is this a pretty good analogy? Is this pretty good?
It's on point. It's
Okay.
exactly.
Right. So the state,
Everybody got their hands out.
yeah, the state's got their hand out saying, because you need us to administer and mediate this issue, we're gonna take somewhere around 45% of the total estate or more just to administer this. But first, we've gotta go through the process of assessing who's who, because we don't want to give this baby away to just anybody, right? So now that's where the arguing and the bickering and the fighting comes into play in court. And now the witnesses got to get called in. They got to get paid. So their hands are out already asking for money. When you bring in an attorney into the case, do attorneys do anything for free? People are saying no, right? If you went to an estate planner, do they do anything for free? You would hope so, because that would be the contractual agreement of their contract, but not everybody's doing business like that, right? We would hope that there are those type of estate planners out there, but they've got their hand out sometimes too, right? And then everybody else. So if you want to avoid that, here it is that let's look at who's participating in the trust, the grantor or the creator of the trust. So that can only be the people who created the estate, the people who created the baby, right? So this is the parents. King Solomon's not involved. No other witnesses are involved. This is the parents, the creator of the estate saying, we're creating an estate. We can also, as the creator of this estate or this trust, we can operate as the manager of the estate, AKA the trustee, right? But if we operate as the creator and the trustee, we can't act as a beneficiary. So you can only occupy 2 out of 3 positions in the case of an estate, right? Or in the case of a trust. So maybe going back to the example that you gave us, madam, if I may, right? Because you brought into the equation thinking about your parents. So let's create a hypothetical scenario for your parents. One, if you are the person who is doing the majority of the financial planning or making the decisions on behalf of your parents, what you have is a trust created by your parents. So the trust is in the name of your parents, mom and dad, your last name, living revocable trust, right? Because we're creating a trust where we can make any adjustments to the trust while your parents are both still alive. And because it's 2 people in the creation of this trust, we're looking at a joint trust more times than not, with rights of survivorship. And that's going to be based on what we want to put into the trust or how we want to spell that out. Now, for those who are not familiar with some of this technical jargon, let me simplify things. So 2 people who are married, right, decide that they're going to join their assets, their belongings, their accounts, and make them one, right? And so now the 2 of them want to make sure that in the event that one person passes before the other person is not locked out from being able to access accounts or benefit while they're still alive. So hence joint trust, 2 people joining together with rights of survivorship. If I go first, you're still taken care of. If you go first, I'm still taken care of. Everybody with me so far? Right? Now, just because they're the creators of the trust, they don't have to be the trustee or the manager of the trust. It could be them totally, because as the creator and grantors of the trust, they want to still be able to benefit and enjoy the assets, the things that they owned and acquired together in their life. They want to still enjoy those things. So maybe when they do that, they don't want to be the manager of the trust. They want to still benefit from the trust while they're alive. So instead, they come to their eldest child and they say, we're going to make you our trustee. How do we do that? Well, the trustee can be issued powers of attorney, right? To manage financial, and medical decisions on behalf of the creators of the trust. All right. The trustee is empowered with these authorized actions. Okay. So long as it's spelled out. And there are trusts that are in place where, because I want you guys to get the most value out of this. I want to make this also the most cost effective for you, right? If someone within your family is going to be managing the trust, it's a labor of love. So there should be no compensation for the trustee. However, because an attorney or an estate planner can also act as a trustee, they can be compensated for their management of the trust. So that can also be spelled out in the trust documents. Is the trustee going to be compensated? Yes or no? If they're family, no, because it's a labor of love, right? And what we're gonna do for them is we're gonna waive all needs for bonds or insurance, and we're gonna waive liability, right? So we need to understand that this person of our family is only gonna do or act in the best interest of the family. So if they make any mistakes, we know that it's not intentional. But we're gonna waive those liabilities. But if it's a third party who we don't know, from Adam or from Eve, slap them with a bond, my friend, we need insurance. We want to make sure that you're going to manage this trust. And if you mess it up, we want to be compensated, right? So powers of attorney, waivers of liability, right? These are other things that you could include into that. But, what else are we looking to do? Well, we're looking to make sure that we take care of the beneficiaries. So now, mom and dad who create that joint trust with rights of survivorship, they empower their firstborn child to act as the trustee, aka the manager of the trust. And what's mom and dad going to do? They're going to act as beneficiaries of the trust. So that way, for the time that they're still alive, they don't have to do anything with the paperwork or the accounts, but they can still enjoy the house that could be easily transferred. That brownstone that you were talking about, it could easily be transferred into the trust as quickly and as easily with a quick claim deed. Just that simple. Okay. I know that we got some questions coming up. One last thing before I start opening up for some more questions, because I want you guys to be clear on this, right? The beneficiary, although you're also the trustee, or because the firstborn child in this particular scenario, right? And remember, all scenarios are different, but for this particular case, we're talking about something specifically for you, because you're the trustee and because your parents are more than likely going to be passing something on to you after they pass. You're also listed as operating within two positions, trustee and beneficiary, right? You'll be one of the primary beneficiaries, if not one of the contingent beneficiaries within the trust. And we'll talk about the trust itself as a designated beneficiary for other things like life insurance or investments or anything else like that. So I know I kind of took up a little bit of time explaining who's participating in a trust, but just real quickly by a nod of head, did that kind of help you understand who's participating in what, how we're basically avoiding probate as well? Okay. So don't go anywhere, because I do want you to come back and ask some more questions, because I like this particular example that we'll probably come back to this as an example throughout the rest of the presentation. I saw the other gentleman raise his finger. He had a question. He put that finger up like he was in church, didn't he? Excuse me,
Hey.
excuse me, pardon me, excuse me.
Some behaviors can't change and
Yeah,
change.
some behaviors just don't go. What's going on?
Well, I think when I went to say, you already answered it. What's in a trust? What do you have in the trust? And also, I have heard you could put a will inside the trust too. What's the main cause that I believe a trust is that you can't change it. Once it's in, it's done. As once if the people transition or ascend, whatever's in the trust, their wishes stays as is.
It's locked. For those
That's it.
who are considering an irrevocable trust, understand that your living revocable trust at the time that one of the creators or grantors, going back to the madam's example, when one of the creators of the trust dies, the trust becomes irrevocable. It cannot be changed. It cannot be altered at that time. After that, it is locked in forever. Okay. So if you've got other clauses in your trust that dictate, who's going to be receiving things, who may be operating a business that's held or owned by the trust, to continue on the family business, so on and so forth, for those who may have businesses, those also would be examples of how you fund the trust. To go back to this question, how do you fund the trust? Easy. A quitclaim deed, opening bank account, right? These are the easiest and simplest ways to, or let me not also forget, transfer, right? These are the quickest ways and easiest ways to fund the trust. Now, based on what you're funding the trust with certain tax exemptions may exist for it, okay? Because the trust itself is an entity designed for the management of a person who is dying or has died, right? So essentially, all assets held in trust are for losses, okay? They're not going to be for the person. They're going to be transferred over to someone else. And so like when they're being transferred to someone else and they're not being held in that individual's name, we just did a couple of things. So one, we took the property out of the tax bracket of the individual, and we put it into the tax bracket or category of the trust. The trust, again, is not obligated or required to pay taxes.
Expand on that, please.
So reasons why some other people don't want you to know this information is because trusts carry with it a zero tax liability, a zero tax obligation, all right? Trusts make purely voluntary tax statements every year simply because they want to make sure that those three-letter boys and girls don't come knocking at the door, right? So I know a lot of us don't want these people knocking at the door. So if you want the people knocking at the door, are you going to avoid filing your taxes, or are you going to avoid having to pay high tax? Which one is which? Just want to ask. You got option A, avoid taxes, or B, avoid having to pay high taxes. I'm seeing thumbs. I'm seeing what I've read some lips. I'm not sure.
Paying
My
high taxes.
avoid
B.
paying high taxes.
B.
B, avoiding paying high taxes. We got 2 for avoiding paying high taxes. Is that also you, madam? Okay, so we got everybody basically agreeing that we want to avoid paying some taxes. Brother, I see you also over there. You trying to avoid paying some high taxes too? While you got a head nod over there too, all right? So we want to help you guys. I want to help you guys avoid having to pay taxes. So a trust, when property is held in a trust, the property held in trust is taxed at the level of the trust. The trust doesn't pay any taxes. What's the tax liability? Zero. I'm reading lips.
Zero.
Zero. Someone said, oh, zero.
Zero.
That's
Right.
right. Okay. And for those of you who haven't maybe heard this expression, own nothing but control everything. So what we're looking to do is establish more control in our lifetime and own absolutely nothing, right? These are some of the strategies that the wealthy 1% employ to avoid having to pay taxes, right? Let's kind of touch a little bit more on taxes too, because let's say that for some of us, we're entrepreneurs, we've got businesses, and it's that time of the year. April 1st is right around the corner. And I'm not talking about April Fool's Day. I'm talking about the basically the last day to file your taxes before them 3-letter agencies come knocking at the door, talking about where my money, right? So because you may have a business, and again, I want to give everybody that's on this call, some value and make sure that we're also talking to the small business owners, the entrepreneurs, because America's economy is dependent on small business owners. Without the small business owner, without the entrepreneur, there is no tax system, there is no social security, there is no American economy whatsoever. The small business owner, when we think about it, goes on to become later on a corporate giant. And what does the corporate giant do? Well, they pay their employees. And what they do when they pay their employees is they write that payroll expense off as an item on their taxes. So they just removed payroll from their taxes. They just lowered the taxes. Also, what they did is they just lowered their taxable profit level and passed it on to the employees. So the employees actually are the ones that are paying the company's taxes. Company is just simply saying, hey, you want your money? Go talk to the W-2 employee that we just paid. Go talk to the 1099 independent contractor that we just paid, right? So the big business is already passing the taxes on. That's one way to do it. Here's how you can also do the same thing. For those of you who are getting ready to renew your business for the year, if you decide that you want to transfer your business into your trust, you can easily do that with your annual renewal. If you read in the state of Florida, which is where I'm at, but also in the state of New York, which I'm also licensed in, and also in the state of Colorado, where I'm also licensed at, state laws allow, and each state is different, right? But the state laws allow you as a business owner to update the information for free when you renew your information. So if you own a business, you're able to, during your renewal process or application, you're able to change the name of the business owner to the name of the trust. On the tax side of things, you'll probably need to file, a document saying that, it's going from an individual with a social security number to a trust with an employer identification number, similar to a corporate EIN. And then now what did we just do? We took a business, put it into a tax exempt shelter, right? And now our business is held in a tax exempt status as well, because the taxes are going to pass along to the owners of the business being a trust. And of course, what's the trust going to do to lower its taxable liability? It's going to pay its employees and its staff and its independent contractor, file its 1099 miscellaneous statements, right? Or its W-2s for its employees, which also by virtue lowers taxable liability of the trust, of the business, and puts it onto the employee. So the only person left paying taxes at the end of the year is the employee on whatever actual income they earn. Sounds pretty good. Can I also give maybe a few more added benefits for tax exempt purposes? Would anybody else be interested in hearing that too? Because I got one more thing that you could do as well.
So I wanted to interject. So
Okay, we got questions. This is what it's all about.
there was this outrage about how Trump doesn't pay taxes, right? And all the while that was going on, I was really wondering the hows, not the what, but actually the how. And he actually stated how he studied the tax code. And
Okay.
I'm like, oh, okay, he's part of the private sector, by way of operating under a trust. You know what I'm saying?
I'm sorry, did you say tribe or child?
I said Trump is part of the private
Oh,
sector.
Trump. Okay, Trump.
Okay, yeah. So yeah, that was it was an outrage about him not paying not just taxes in general. And he just said he studied the tax code, and this is
Yeah,
probably this is most likely the way he's operating under a trust.
And he does, like for those that are not familiar with how Donald Trump actually became, inherited his wealth. It wasn't through his father. For those of you who may think that, oh, like he inherited a real estate empire from his father. No, actually, his grandma Trump's grandmother was, after she immigrated to the United States, she started investing into the stock market. She invested so much into the stock market early enough that when she passed, she left her son a couple $1,000,000. Of course, her son, went on to invest into real estate, and the rest is history. We know what happens there. But Trump essentially was a trust fund baby, right? And we can kind of touch on this real quick because I know some of us on this call, we have children, right? So let's kind of dive into this idea of like trust fund babies real quick and like relate that to Donald Trump and what he's done. Okay? So Donald Trump might be too old of a reference for some of us, but anybody familiar with the Hiltons, right? As
Paris
in
Hilton.
Paris Hilton, Hilton Hotels, right? So Mr. Hilton, Paris Hilton's father, did really well in hospitality and in real estate because, of course, you got to own the property to build a hotel on top of it, which later on became a franchise business, right? So they got private investors and things like that. In the process of that, Mr. Hilton, his income level was well above the estate tax limit, which is 22 million. It's actually, excuse me, it's 11 million for individuals, but for joint married couples, they're able to enjoy a $22 million estate tax benefit, right? So the limit goes up higher for those who are married, right? So they got it. And we're going to keep it in like today's terms, all right? Today's numbers. So 22 million is current. That's for today, right? What happens is because there are tax advantages for the wealthy who exceed the $22 million mark, they created an irrevocable trust, which also had a spendthrift clause. Spendthrift clause is to protect the trust from the beneficiaries, bad spending, or financial management skills, right? Like, let's say that they don't have it, right? And clearly, Paris Hilton didn't really have too much skill to manage her assets. So Mr. Hilton had a trustee, a competent third party managing the trust on behalf of his daughters. They didn't ever touch the trust, right? So in so many ways, their trust acts like an annuity because it makes sure that they've got income for their entire life. They can't exhaust the money that's in there simply because Mr. Hilton created a trust fund that his daughters to this day still enjoy, right? And it put all the necessary protections in place, right? Now, because the beneficiaries inherited millions, if not a $1 billion legacy, well, the taxes for the inheritance were also reduced to that of the trust, which was how much again, ladies and gentlemen?
A lot of money. Over 22 million.
22 million is the exemption, right? That's where the
Yep.
limitation stops for married
Mhm.
couples. So
11 million.
11 million on individuals. So we understand that, like, if we're thinking about how to properly plan, we just also got something there for those of you who may have just missed it. I don't want you to miss out on this nugget. Okay, so let me rewind it a little bit so you get this little nibble, right? Just a little sip of something good to, wet the whistle, okay? We know that the tax limit is at $11 million for each individual. So if you got $1 billion estate, multi-million-dollar estate, right? What do? You create multiple trusts that all meet that 11 million cap, and then you diversify with your different accounts, right? You put your money other places. Did anybody just catch that? No, I don't think you guys just caught it. Like I see you guys nodding your head, but I
So
think
I'll give you an example, right? So Biden, he he administered the capital gains tax, right, on investments or investment portfolios. So to litigate that, we have to create multiple um investment portfolios to diversify the account, so we'll not breach that the cap.
you're absolutely right. And when you think about when it comes to investments, we have to change some things around a little bit, right? Because we just talked about the tax advantages for the estate, for the trust, right? When it comes to investments, we have to think about the Securities Industry Protection Corporation, the SIPC. These guys are like the FDIC, the Federal Deposit Insurance Company, except they're not insuring your bank account for 250,000. They're basically covering your investment account for $500 worth of securities and up to $250,000 in cash. So you have the $500,000 in securities, then a $250,000 limitation in cash. So what do? You create multiple investment accounts that also meet those requirements, and now you've created a much more diversified portfolio that's also covered its assets, aka its ass, and made sure that each investment account hits the $500 securities or investment cap, and then the $250 cash amount cap, right? So when we're talking to people with like billions of dollars, if a person had let's just use a low end number like $1 million, right? So we could create one investment account at $500,000 with $250,000 in cash, and then we have a remaining $250,000 left over that either A, we use it for income, B, we diversify and we put it into another investment, which also a possibility, or we make sure that we've got our income protection in place, depending on how old we are, because maybe we still got a lot of risk left.
Right.
So does that make sense?
Yeah, as it relates to the investment portfolios, sure. I mean,
Okay.
relating to the trust as well.
Well, it does relate to the trust because even a trust can have an investment account,
Right.
right? And on that investment account, let's say that a trust doesn't have an investment account. Let's say an individual has an investment account. Well, that individual can list their trust as either the primary or the secondary beneficiary, depending on if they're married and they just want to make sure that their spouse inherits, and gets direct access to the accounts. But if that's the case, we just left the spouse's information subject to the public. For some people, they may want that. Other people, I want discretion. I don't want anybody knowing who's going to receive what from my estate.
Right.
I'd prefer to make my trust primary beneficiary. And again, this is me. I want everyone on this call to recognize what's suitable and appropriate for them. Me, I don't want my loved ones' public information, their information public. I don't want that, right? But if I didn't care, or that was privacy wasn't a concern or one of the things that was on my mind, then sure, I might make the decision of saying, oh, my spouse, yeah, they can go ahead and be the primary beneficiary. And if they don't die, if they do die, the trust will become the secondary beneficiary and everything will move to the trust the way that I want it to. Right? So, a really good question there. So I do hope that helped. I saw someone else just unmuted themselves. Someone else has a question or a comment?
Wow, you got good eyes. Stop watching it like that. Okay. Dang, like I didn't raise my hand yet. Just an overview of what you was just speaking on. So a trust, basically, once you set a trust, revocable trust. While you're still alive, you can make any changes to it. Once you transition, it's locked, sealed, and done. Your wishes that's in the trust stays as is. It cannot be disputed. It can't be changed unless stipulated within inside the trust. And then if I'm not mistaken, correct me if I'm wrong, that once you drop your assets into the trust, it now comes off of your liability. You have no liability no more. Back to the saying that control everything, own nothing. So if I want to stay beyond the Medicaid type of threshold, just drop my asset into the trust. And I think the time frame is 2 years that, they see nothing. Copy. And then within the trust, if I look at your whiteboard, you have the POA, the waiver liability, and what else? Oh, that's it, right? Well, yeah, for that. And then the manager, the trustee manager just controls how things move and what goes to fro by the wishes of the trustees. The
Of
trustee.
the creators of the trust.
That's got it. Copy of the creator of the trust. Cool. I've also, FYI, whoever got businesses out there that was filed last year, don't forget to put down your beneficial ownership information. If you don't, it's $500 a day fine. So
Sir.
everybody's trying to play that shell game and take their business and drop it in the trust. Be careful.
Yeah, you got a great point, but when it comes to that, basically the trustee just has to write that out, That's all. It's just that simple. So reasons why you also want to do your voluntary filing, so that way you avoid some of these other things like these new laws that come out. You know what I mean? Like the tax law changes every 4 to 6 years, right? It changes every 4 years, but it takes 6 years for each new policy to really like kick into effect and then be removed. If it's like, because taxes are regulated by the president and by Congress. They're in control of fiscal policy. They're in control of like determining how much they're gonna, allow business owners to write off, how much they're gonna, state are the limitations for, investing into FICA and Medicare, these other things. Well, reduce your taxable liability, give the government as little as possible by doing the proper planning. And, I got to say thank you, sir, because I don't even have to do a recap now. You recapped it so well. I got to let you do this presentation next time.
So when you was saying that, you were saying how long it'll take before the law go into effect?
It's
Just
in
about.
effect now.
You said it's in effect now.
Yes. If your corporation was made last year, you had the end of this year. If you make a corporation this year, they gotta be filed 30 days.
So we got to the end of this year to state the beneficial owner of the trip. I mean, the business.
Put that BOI in. Yes, sir.
So interesting because when that news came out, my auntie was the first one to hit me up like, hey, you might want to close your business.
Yeah,
And then
if
my,
you're not so involved in it, you might want to close it.
my brother panicked. He was like, "Hey, bro, close my business for me." I'm like, "Why you telling me?" But
And
no,
it's really to stop money laundering. They want to
It
know
is.
who's behind the corporations. That's all. But if you got nothing to hide, you got nothing to worry about.
yeah,
Right.
that's what that was my main
And
thought.
even with when you drop it in the holding companies, I'm sorry, we're going up in a tangent. But let me go
No.
back. Let me let this release this back to the trustee, the trust.
Right now.
Yeah,
So,
no, but you bring up a very good point. You know, like a holding company is, let's briefly talk about that, and like I'll leave that maybe for another conversation. Um, again, it's a, I don't know if anyone's familiar with tapas. It's like Latin cuisine, like it's just like really small portions of meals. Like it's popular in New York and in South Florida. But in any case, you know, little samples of things to maybe bring up in a future conversation, and maybe depending on like, you know, what you guys say, holding company, right? A trust can act as a holding company in the sense that, one, a trust is not required to register with the Secretary of State like a business is, right? So essentially, a trust can stay private for its entire existence, meaning it never registers with the Secretary of State, right? It can own businesses that register with the Secretary of State, but the trust itself, never is required to register. So acting as a holding company where you're just, the trust is just holding assets. Don't forget that your holding company, which holds those assets, can also charge a fee to the businesses, and also like in the event that there was a tax obligation, trust just satisfied that by acting as holding company.
So state question statement. So within that thought, and then if for generational wealth purposes, would it be wise to have one of the beneficiaries on the insurance or the insurance policy to be named as into the trust to add money into that account?
I I would certainly look at it from that perspective, right? Because again, if you're like me, and it kind of sounds like you're a little bit like myself, and you want to keep your assets and your estate private, you don't want anybody else involved, then yeah, add the trust to your policy as the primary beneficiary, write it off as 100%, and let whatever provisions that are stipulated in the trust be how the beneficiaries receive what's poured into the trust, right? That's it. And then like, what can the trust do? Well, the trust can write off their payments or any money that they're giving to the beneficiaries as a gift. And does anybody know what the tax liability is on a gift?
God, I forgot. I forgot, 7 or 10,000? What?
The gift tax allowance is at 10,000,
Yes.
right? If you're married, you double that number, it becomes 20,000, right? You see how we're making this very simple? We're making finance very, very simple, not complicated. Now you guys understand how these tax laws apply to your account. You can be single tax or you can be jointly taxed. But when you're jointly taxed, you have a higher limitation. So you can write more off, right? The husband gives a lot more gifts than the wife. At the end of the year, the husband gave $15,000 in gifts, but instead of him writing off all 15,000 under himself, he applies 5,000 to his wife, and now they've got a 20,000. They've still got $5,000 left to utilize, you know, their limits. What are we doing? We're not doing anything illegal. The IRS incentivizes us to do these things. They incentivize us to do this. How do I know? Because the tax code says it. Tax code says it. All right.
Because the Bible tells me so, but yeah, the tax code, the Bible, because the tax code said it so.
Because the tax code tells me so. That's right. You know, red and yellow, black or white, they are precious in the sight. You know, hey, exemptions to everybody. You get an exemption. You get an exemption. You get an
That's it.
exemption. You know, so guys and gals, we're 7 minutes past the time that I wanted to take up your time. I hope that some of what you heard has been insightful, maybe gave you a couple of aha moments. Definitely take a screenshot of this before I close out. Or you know, take a picture of it before you get off the call. But for those of you who may be interested in, you know, having a one-on-one conversation or a group conversation with yourself and some of your loved ones, definitely feel free to reach out to me. For those of you who have my number, you have my number. For those of you who don't, talk to the person who invited you to our call tonight. And you know, let's have a conversation about what's in your best interest. How can we help your family, right? How can we create intergenerational wealth that you can actually pass on to your loved ones, right? It may not, we don't even have to do it directly to the people that you wanted to go to. It could be to the people that you don't, we skip the people that you don't want it to go to the people you do want it to go to, right? In other words, generation skipping trust, right? Because maybe you got siblings that maybe they may feel differently, and your parents are saying, you know what, our kids would fight, but our grandkids are gonna love us. So let's skip our children and make sure that the grandchildren get this, and we'll just put that type of a stipulation into the trust as well. I've said too much. All right, just a little extra, something extra. You know, we're out of here. You guys, all right. Thank you for your time. I hope you've enjoyed this, and you know, thank you very, very much for your time and
Great